Child support can be modified a couple of different ways. One, the easiest way is that if you are paid child support through the probation department, probation will automatically do a COLA adjustment, a cost of living adjustment, which is typically about 3% on the base child support amount. That would not be on the arrears, just on the base child support amount. The other way that you can do an adjustment is if there is a change or a substantial change in the earning of either party, the household of either party, or the expenses. So to break that down, if you or your former spouse has a change of income, up or down, that can be a change of circumstance. If you have another biological child or adopted child for whom you have a support obligation, that can be a change of circumstance. If you get a new job and you now have mandatory pension deductions, or there's a change in the health insurance cost, or any substantial deviation from the original award, that can all combine to create a change in circumstance. So the key takeaway is that a modification of child support can come from either a cost of living adjustment through probation, or in the alternative, a substantial change in circumstance to either yourself or the recipient of child support. If you do not have a probation account so that the cost of living adjustment is automatic, then you would make an application through the court to modify child support. That would be done by way of filing a motion when we would present what you wanted, why you wanted it, and whatever proofs we can provide to support your income, your assets, and your expenses. A lot of people think you could just go to court and ask for a change and just give your tax return or give your pay stub. You have to do a complete financial picture so the court can get an understanding of what is the change. The other consideration when you're deciding if you're going to apply for a downward modification particularly is that support is based on all of your income. It is not based on your base salary. So if you are an employee who receives a base salary plus commission, or a base plus end of the year bonus, or stocks, or whatever the case may be, all of that compensation would have to be considered in any modification. If you're not getting paid or you are not paying your support obligation, then an enforcement action can be filed by you or against you. And an enforcement application comes from one of two sources. Either the recipient of child support going to court and asking the court to enter an order that you have violated the terms of a prior order and that you owe support, and to quantify the amount of support that you owe. Or it can come in the form of a probation enforcement hearing, which is where probation goes to court and says this person hasn't paid their support, at which time the court would enter an order enforcing the support, determining how you're going to pay it back, and in a worst case scenario, if there's a continued violation, they could issue a bench warrant, which would then give you a lump sum payment in order to get out of jail. I get a lot of calls asking about modifying support. And that is one of those areas that I try to really guide people, because there's always this thought that because time has passed, or because my ex is making more money, that the support should go down. That's not necessarily the truth. Or you have the school of thought that time has passed and the child is now, going away or at the community college, but living at home, that I should not have to pay support. That's not true either. So whenever someone comes to me to ask for a modification of support, the very, very first thing I do is sit together, run through some tentative schedules of what support could look like to see if it even makes sense to make this application. At the end of the day, the decision is the client. So if you want to push forward with a modification, I can help you with that. But before we do that, I want to make sure you have some realistic expectations of what you may or may not gain through that process, particularly if you're seeking a modification when in fact you're in violation of other orders, because you may win the battle but lose the war. So we want to have a really full picture of what is your best next step, because sometimes what you think is your best next step turns out to be potentially one of your worst. If you have any questions about modification, child support, enforcement of child support, or your rights relative to your support obligation, give us a call at Jersey Coast Family Law.